Thank you, Chair.
Yes, Ms. Hassim.
Chair, we are here to start the morning's proceedings at the behest of the legal representatives for Mr. Matlala on the basis of an application that they brought on the 21st of August. As the Chair and the Commissioners will recall, there was a very strict time frame that was issued for the delivery of pleadings in that application.
Was it in this matter that for the first time I even said there should be no slippages, or was it in another matter?
It was in this very application, Chair,
Yes.
In which you emphasized that there will be no slippage, and you were precise about the time at which the various pleadings and heads of argument ought to be filed. So we have, as the evidence leaders, there was an affidavit filed, not on time, on Saturday. It was 45 minutes late. The evidence leaders responded to that by means of an answering affidavit that was filed according to the schedule.
Was there an explanation, even if informal in the sense of a letter as opposed to perhaps an application for condonation? I've not seen an application for condonation, but at least an informal explanation, say by letter, for example,
Chair,
for their lateness, for Mr. Matlala's lateness.
What I'm advised is that there was a delay in obtaining the signature from Mr. Matlala. We then requested the unsigned version. So what was 45 minutes late was the unsigned version. We don't know why that could not have been provided on time, because it was the unsigned version, with a later to follow. The later signed version came much later in the day. We don't have any further explanation for it, and my learned friend will no doubt have to address the Chair on that. But just to put the order of events in context. This is in the context of the ruling. The evidence leaders then filed the answering affidavit, which was due at 10 o'clock on Saturday morning. That was duly filed. The second aspect that we were required to address was heads of argument based on the application. Those heads were due at 6 p.m. on Saturday. They were duly filed at 6 p.m. on Saturday. What we did not receive by the evidence leaders, what we did not receive was the replying affidavit from the representatives for Mr. Matlala, which was also due at 6 p.m. on Saturday, nor did we receive heads of argument. We've not got an explanation other than a letter, and Chair, if I may take you to that letter. I'm not sure if it's in your correspondence bundle or if it is provided to you separately. It's a letter that was provided on Saturday at 5:05 p.m.
But if it's a letter that, amongst others, says Ms. van den Heever could not attend the consultation, she was not well, and also talking about the replying affidavit and written submissions which were not filed. We have had sight of it.
That's the letter I'm referring to.
Yes.
What we understood from that was that there was still a consultation to take place with their client, and that we would receive the replying affidavit or the heads at some point on Sunday. It never arrived. I must also say that the heads of argument, of course, are not dependent on the consultation with the client. The heads of argument could have been provided. As we sit here, we do not know what the legal basis is for this application, other than broad assertions of the privilege against self-incrimination and what we've seen from the affidavit that they wish to rely on a challenge that they intend to bring in the pending trial in relation to the chats and the recordings as being unconstitutionally obtained evidence. I'm not going to stray into the merits of our opposition to the application at this point, Chair, because I'm jumping the gun. My learned friend must address you first. All I want to do to begin with is to place in context how we are sitting here before you today, which is We have filed our answering affidavit and heads of argument. We've received nothing from my learned friend. And we've not received a condemnation application or a postponement application.
All right, all right.
And I think once my learned friend addresses you on the merits, I can then turn to the merits.
Thank you. Thank you, Ms. Hassim. Ms. Missy, let me start by correcting myself before you address us. I gave instructions very early this morning that a directive be sent out that in the event that a postponement is not granted, I direct that only 30 minutes of argument will be allocated. I referred to a postponement because of an erroneous recollection of the contents of the letter that Ms. Hassim has just referred to. My memory, which was a lapse, was of the view that that same letter also sought a postponement. My co-commissioners this morning corrected me and said the letter does not seek a postponement. So I thought I should, in case my directive created confusion, just correct myself up front. But I must say this, if we get to the point where the application has to be argued, my directive as to time allocation stands. Let's hear you.
Thank you, Chair. I've considered how I would address the Commission with regards to this, and I deem it important to refer to a folktale that I've often heard in the corporate world. And the story goes that a security guard was once informed that the boss or the CEO of the company has given instructions that before 6 a.m., no one ought to enter the building. And the said CEO, on another day, attempts to enter the building before 6 a.m. And what he's told by the security guard is that, boss, you will not enter here. I was told that you do not enter before 6. It does not matter whether you are the CEO or you are the one that gave the rule. I will not open for you. And I proceed with that because I want the Commission to get a proper understanding upon which the entire team of Mr. Matlala labors under. Correct. One would note, as correctly put before the Commission by Ms. Adila Hassim, that we did endeavor to provide them with an unsigned affidavit 45 minutes late. That's correct. It then took us approximately 3 hours to file our subsequent signed affidavit. Logically, as an individual, a layperson sitting anywhere would wonder to themselves, but if you had an unsigned affidavit and you only needed for your client to consult, make whatever changes you needed to make, why would it possibly take you 3 hours for you to then get a signed affidavit that's commissioned and file it and serve it on the evidence leaders? And that should give you a picture of how difficult it is for you to get access onto the premises, to get driven from your entrance as a visitor all the way into CMEX. When you enter the entrance at CMEX, how long you have to wait to get searched to complete the forms for you to then get taken from that point and walk into CMEX, where you also at that point have to wait for somebody to come and take you up to the boardroom that we have fortunately been allocated by management within CMEX. You then are in there, you're not allowed to have your cell phone devices, which in this day and age, that's what we primarily depend on to get access to the internet. With that being said, we would then have to go through the affidavit. You go through the affidavit, you make the changes. You now have to call said individual to come back and to take you guys downstairs for somebody to open the door for you to get out. You are not allowed, and I actually have got a tongue lashing personally by the management of security at CMEX, informing me that I do not understand and cannot comprehend the level of security and risk that I'm putting myself under by wanting to roam around the CMEX prison without somebody there to guard me and to accompany me. I then was taken to another office where I had to wait for somebody to come and take me to walk out and go to the security with my learned friend, my instructing attorney rather. We then waited approximately 30 minutes to get a ride from CMEX all the way to the gate. We would be able to get access to our phones, get the internet, and for us to then, I apologize for that, and for him to then go and print the affidavit and then come back. That is a process on its own. We then have to start again, request for us to get a pickup to go back to CMEX, follow the whole process, somebody to pick us up as I had explained initially. And that on its own tells you the difficulty under which we have to labor to get an act that would ordinarily take plus minus 35 minutes to get done. But it took us almost double the time. Over and above that, we did indicate to the evidence leaders that we had an issue because our lead counsel, Ms. Van Hever, was the one who was scheduled to go and consult with Mr. Matlala. So on the way there, when they had received the replying affidavit, she was unable to consult. She turned back home. And by the time we were able to speak to her, I couldn't go back in. I'm then further instructed by I'm told by my instructing attorney that even when he arrived, he was not allowed to go and consult where we were allocated to consult previously. He was treated as an ordinary visitor. So all he could do was hand over to Mr. Matlala the answering affidavit rather, and explain to him his understanding of the legal issues and the position that we would take going forward. Mr. Matlala then gave him instructions that he would need to read the replying affidavit and he wants to consider the limited advice that he has received from the instructing attorney, and that he also wants to hear the position that is being taken by us as counsel. And again, you note, we don't have cell phone devices. He does not have access rather to a computer where we could possibly send him an email and maybe in the evening he could quickly just see what it is that we've said and maybe then before we arrive he would have a position and we could proceed. On Sunday, Ms. Van Hever then gives me instructions to go with our instructing attorney to attend to this consultation with Mr. Matlala. I personally attended to it. I had to grovel with the head of security and beg for him to at least give us 5 minutes to engage with Mr. Matlala so that we would be able to at least give him an idea where we stand and then hopefully we can get some instructions. Over and above that, while we're at the prison, we then receive another affidavit from the evidence leaders, which they intend on using. That same affidavit I had to quickly give to Mr. Matlala to glance through. He didn't even get an opportunity to read it and to give us a position, and we do believe that he has to address it in the replying affidavits at minimum.
Is that other affidavit the one deposed to by the senior investigator, Mr. Dlamini?
That's correct, Chair. That's correct. And so with that being said, the limited time that we had while trying to balance getting information from Mr. Matlala and maintain relationships with the individuals that tomorrow we have to come back again and beg on a Sunday if necessary to give us access to him. We then had to respect the time that they had given us, quickly give him what we gave him, have him glance through the affidavit, at which myself personally, I had not read through and I couldn't even give him an idea of exactly what is being said in the affidavit, except to say it was from the lead investigator and it has to do with a consultation that they heard on an earlier encounter with the evidence leaders, I believe. With that being said, we were unable to get instructions from him. The little information that we got required us to then create a strategy of how we'll move forward and still be efficient. And our conclusion was that the best way to move forward would be for the instructing attorney to go through the docket again, go through the section 204 affidavit so that he can adequately provide evidence depose to an affidavit that is correct and properly represents Mr. Matlala. We have not been able to conclude that process, and as a result, we were unable to file our replying affidavit as we had intended to on Sunday, Chair. With that being said, from Saturday, Ms. Van Hever has been sick. And I do believe in her first appearance on behalf of Mr. Matlala, at some point she intimated that she suffers from rheumatoid arthritis. That has put her in a position where she's so ill. I was engaging with her this morning. She can't use her hands or feet. She's with the doctor and they're consulting to see a way forward. But what she did guarantee me is that hopefully with the medication that she's receiving, by the afternoon, she'll be in a proper position where she'll be able to continue with us working and appear tomorrow to argue. So my instructions right now having considered the fact that we are constantly being hit with umthetho awuvumi, you cannot do this or that, and we have to try and navigate the systems where ordinarily a layperson not sitting in this commission would think, well, these individuals are incompetent, or maybe perhaps they're trying to not come before this commission in good faith. That is not the position. You have to be in it to truly understand what it takes for you to properly represent Mr. Matlala, because he is not an ordinary witness that you have access to at 12 a.m. rather in the morning, or at 3 a.m. in the morning. We don't have that liberty before us. And I do know with regards to the additional bundles that we receive later on, they make it even harder because he wants to read. He wants to know what's being said there so that he can give us proper instructions moving forward. He's not in a position where he feels comfortable that it would be smart and wise for him, given the status that he holds outside of the commission, to say to the commission, well, I did say this, let's go ahead, without considering the implications that it would have on him. And we beg this commission, humbly so, Chair, to consider all the elements that we consistently have to deal with to try and ensure that we represent Mr. Matlala, and also stand before the commission in good faith, that we're given an opportunity to file that replying affidavit, our heads of argument, and as well as a written condemnation application for the late filing. Thank you, Chair.
Thank you, Ms. Missy. Yes.
Chair, just 3 points
May
in response.
I just raise an issue, Ms. Missy? What the evidence leaders answering affidavit raises is a legal question, or rather what it raises are legal questions, 100%. So I don't understand this issue of agonizing over how, when to consult Mr. Matlala with regard to a replying affidavit. Those are legal questions which would not necessarily have required Mr. Matlala. Those are legal questions that you, as lawyers, should have been able to respond to. Truth be told, actually, there wasn't even a need for a replying affidavit. You could just have put together written submissions, and you would not have been out of time. So I have difficulty understanding the difficulties that you say you had.
Chair, yes, to the effect that it relates to legal issues. But there's also information during their consultation, as limited as it was, where it became clear to us, having had sight of the replying affidavit, that there's factual elements that need to be addressed that relates to documentation which we did not, or rather they did not have at hand when they were consulting. To say to that, we received a further document this morning from Mr. Matlala that he was unable to go and obtain from his the room or the prison cell that he's been kept in. And it speaks directly to the issues that would have to address in terms of the legal points. So there's a special element
that's very
to it as well.
peripheral. Those issues about whether Mr. Matlala received certain documents a day or two before the hearing of his testimony, those are very peripheral issues, and they have nothing to do with the legal questions that Mr. Matlala's application raises. So I think my point stands.
Chair, I did not hear the last few words that you said.
I said I think my point stands.
Noted, Chair. Noted.
You are free to respond. I'm not a dictator.
No, Chair, I believe what I've set down in terms of the entire process and how we found ourselves here today I can't explain it any further than what I already have, Chair. And as I stated earlier on, I can only beg this commission to take into consideration and to give us a chance up until
I'm
tomorrow
listening, you
morning,
may
Chair.
continue.
Thank you, Chair.
Let me indicate what my inclination is, which you would obviously have seen in the directive that I issued. In fact, I sent it out to the attorneys after 6 a.m. I don't know what time they instructing them to write a letter to Mr. Matlala's attorneys. I don't know what time that email was sent, but I gave the instruction after 6 a.m. My inclination is for Mr. Matlala's application to be argued now, this morning. That's my inclination. What's your response to that?
Chair, my application for a standout from tomorrow, still, that is the position that we're taking. If the chairperson could grant us that opportunity to come before this commission prepared, and at least for you to have sight on paper, at minimum, some of the case law, because we do believe that this is an issue that has never been dealt with by any commission in South Africa. Speaking to the position that we find Mr. Matlala in, and we do deem it imperative that you have sides, yes, of the legal argument, but also the case law that we rely on to make out this argument. I don't know how efficient it will be, given that it's a constitutional issue and the position that we find ourselves in, and we've tried to look and research to see internationally if we could find something that could give us guidance on this here, on the issue that we intend on arguing. And we do believe that it would be of a benefit to the Commission to have sight of the case law in our written submissions, Chair. I don't know how beneficial it would be if I only argue this and you are unable to make reference to those cases and the paragraphs and see exactly, is she applying herself correctly? Do you agree with me, yes or no? And what's the position? And I think perhaps that's the consideration you'd have to make in finality, which is one, this is a position that we believe any commission here in South Africa has never had to deal with and answer and consider. And perhaps it would be beneficial to have consideration of the cases that we would like to refer to or refer the commission to, Chair. Thank you.
Thank you. I will go back to the question that I asked about this being a legal question. This is something that Ms. Vandenheefer was quite passionate about from the day of the last appearance. She referred a number of times to an application where points in limine would be raised. From the moment that you start thinking about bringing an application in which you are going to raise points in limine, you already know what the law that supports you is. So it should have been a matter of relative ease. In fact, even easier for you, Ms. Vandenheefer, Mr. Matlala's lawyers, to argue the law than it would be for the evidence leaders on whom you are springing these points in limine. So I'm not sure that I follow your response. Can you tell me why written submissions were not or could not be filed on legal issues that were the start of all this, legal issues that you thought of even before commencing this, the process that we have before us this morning? And underline, you were ready with the law right from the beginning. Otherwise, you would not have even considered bringing an application in which points in limine were being raised.
Chair, I can only take you back to the fact that from our consideration was that it was imperative for us to prepare the replying affidavit. My apologies. From our considerations, we found it or deemed it imperative for us to prepare the replying affidavit and to get further instructions from Mr. Matlala with regards to the position that we're taking. And I do note the point that you're making that perhaps what we could have done in the interim was prepare the heads of arguments to assist the commission and have them filed on time. I take note of that, Chair. But that was a delay that came as a result of the consultation, the considerations that we had to make, which is that given the answering affidavit, we deem it important to get further instructions from client with regards to the replying affidavit before we proceed with penning down the position that we've taken with regards to the application. That's as far as I can take it, Chair.
Morning, Ms. Missy. The point is simply this. Mr. Matlala would not have assisted with the law because the law is for lawyers to research and to argue. He could only have assisted with the facts and the giving of instructions as far as whether he wants to persist his application. But the law is for the lawyers, and the moment they advised him to bring this application, this was the time to start considering, especially being aware of the strict timelines under which this commission operates. We simply cannot afford a wasted day because our schedule is already very tight, and that is the difficulty we find ourselves in.
Commissioner, it goes back to the considerations that we made. If I have to make further submissions, then I have to make up stories, and I'm not prepared to do so. What I have explained to the Commission is the step-by-step process that we've gone through, and I do take note of the points that both yourself and Chairperson are raising. Thank you.
Yes, Ms. Hassim. Perhaps let me just ask this quick question of Ms. Sillo. How much longer do you think Mr. Matlala's testimony will take? I know those estimates have regularly been overshot.
I know, Chair, and in this case, it shall be particularly so because Mr. Matlala's testimony in truth hasn't even begun. So all he's done is read his statement into the record, which he has sort of supplemented through this application. I guess he may want to place that also on record. We had anticipated a minimum of 2 days after he has placed his statements on record, Chair.
So today and tomorrow?
Today and tomorrow. A minimum of 2 days. Thank you, Chair.
All right, thank you, Ms. Sillo. Yes, Ms. Hassim.
Chair, just a few responses to what Ms. Nisi has submitted. The first is, and just to correct some of the facts. The first point relates to the filing of the founding affidavit. It was due at 10 a.m. on Friday. This was subsequent to the directive of the chair that was made on Monday. So there was a long period between Monday and Friday for the purposes of consultation with their client before the filing of the first affidavit. So the long explanation that was given about the difficulties with accessing the client in correctional services doesn't really assist in relation to the founding affidavit because there was sufficient time. But it's not only sufficient time from the period between Monday and Friday last week. Mr. Matlala's legal representatives have been raising this issue for some time, prior even to Monday. They are aware of the categories of evidence that the evidence leaders wish to canvass with him in questioning. They've known this since at least March of this year. So this application could have been brought much sooner. And so all of the time, in fact, that was available to Mr. Matlala's legal team extends over months, not over days. So that's just to address the founding affidavit and the explanation for the lateness, which I say doesn't assist Mr. Matlala's team. The second point is about the heads. and I'm not going to repeat it because, Chair, you've made the point and Commissioner Khumalo has made the point. Those are legal, that's legal argument. There's a legal team that's assisting Mr. Matlala. The heads of argument could have been submitted timeously, and they weren't. There was no need for consultation in relation to the heads of argument. Preliminary points are by their nature legal submissions. The second point,
Please continue.
on the point of the legal submissions, you would have seen from our answering affidavit that we set out the legal principles. It's not true that this is not circumstances that have arisen in a commission before. That is not correct. The authority that we have submitted to the commission that we say is the controlling authority is the Secretary of the Judicial Commission versus Zuma, the Constitutional Court judgment, and specifically the judgment by Justice Jafta, which was a unanimous judgment. And we referred to paragraphs of that judgment, which we say is the governing authority to be considered here. So the law on how one should deal with the assertion of the privilege against self-incrimination in a commission.
Just explain the point about the judgment having been unanimous.
The judgment by Justice Jafta on the point of self-incrimination and the assertion of the privilege against self-incrimination in a commission of inquiry. So that's a judgment on which we have relied. We set out the legal principles in the answering affidavit even before we filed our heads. That's just in relation to the point on the privilege, the section 3, subsection 4 point. The second legal point was in relation to unconstitutionally obtained evidence. And there too, we set out the legal principles in the answering affidavit even before we got to the heads of argument. And the point I'm making is that these are legal submissions. That's why our affidavit sets out the legal principles. And there we explained why the argument that Mr. Matlala is entitled to blanket immunity from questioning in relation to broad categories of topics is not available. It's not a competent relief that they were seeking from this commission. That was already set out in our answering affidavit. So it's not correct that there's no law on this and that they needed to have more time. Quite apart from the important points that you and Commissioner Khumalo have already made, that this is something that's been brewing for some time by Ms. van den Heerfer. The third point is just in relation to, I just want to correct the Dlamini affidavit. It is correct, it's true that the Dlamini affidavit was filed with the commission and submitted to Mr. Matlala's legal team this weekend. But that's not part of the application that's before the commission today. It's entirely separate. And that should not hold up the argument on the application. Those actually are my submissions. Chair, I think that the commission will decide on how much of time, if at all, any time is to be granted to my learned friends. But the argument is there from our side. We are ready to respond. Our concern as evidence leaders, as we've contained, as we've set it out in the heads of argument, we wish to have the application dismissed, and we want the questioning of Mr. Matlala to proceed immediately because time is short.
Thank you,
Thank you, Chair.
Ms. Hassim.
I'm sorry, Chair. There's one last point
Yes,
I've
yes,
forgotten,
yes.
and it's sitting here in front of me. I'm sorry about this, Chair, but we also received communication yesterday, and this is something that perhaps my learned friend will want to consider and advise on. It wasn't apparent to us yesterday whether, in fact, Mr. Matlala's legal representatives were abandoning the application. And I say so because last night at 20:51, we received an email from his attorneys And the email says the following, if I may read it into the record, Chair. It says, "Good evening, evidence leader. We respectfully request your urgent written clarification regarding the scope of permissible questions on record. As discussed yesterday, certain questions are excluded due to the pending criminal matter. We attempted to send an email to this effect, but it appears our system may be experiencing technical difficulties. To avoid any procedural uncertainty, kindly confirm in writing which questions may be asked and which are excluded. This confirmation is necessary to ensure proper management of the record and safeguard procedural fairness. We would appreciate your written response." The response to this letter was as follows. Greetings and salutations, and then please note that until the commissioners rule otherwise, there are no questions relevant to the terms of reference which we treat as being impermissible. So that was the correspondence between the two sides yesterday. It was quite confusing to us what the meaning of this was, because what it suggests is a request for the questions, what questions we intend to pose. From that, we thought that maybe the approach being taken is to proceed on the basis of pose the question and then the privilege will be asserted once questions are posed. And so I think that my learned friend may need to just also clarify that.
Ms. Missy, does the letter mean that the application is abandoned, or what does it mean?
Chair, no, the application is not abandoned. The reason for the email is we're trying to anticipate an instance where the ruling perhaps doesn't go in our way. And Chair, based on the ruling that you would make, then Mr. Matlala would then have to apply the right against self-incrimination as and when the questions come. And I believe the thought process was that when it comes to those topics that he cannot claim privilege over, then what are those topics that we can anticipate an engagement over so we can prepare with regards to that? It was not to indicate in any shape or form to my learned friends that we are abandoning the application.
Yes, I must say that it was a very strange request. One can't quite tell whether the request was for all the questions that are going to be asked to be itemized, which would be something that's unheard of and in fact quite bluntly very strange.
Chair, I do take note of the wording as well, the confusion that would have come from it, but my understanding was that I think the attempt was to ask under which topics are we going to proceed on once the commission has made a ruling with regards to whether we can proceed or the argument that we make brings the entire process to a halt. Thank you, Chair.
Thank you. May we see counsel outside, please? Ms. Missy, we were advised that we should come back earlier than midday, and that this was at your instance. Yes.
That is correct, Chair. When we were excused or stood down, rather, we received further instructions from Mr. Matlala, having heard the engagement that we had prior to the stand down. And the position that is taken is that he feels that it's unfair that the commission is putting him in a position where he has to proceed where his lead counsel, one, is not here, obviously not of her own doing, but because of an illness that became rather sudden in the manner that it's attacked her. Two, because we've intimated that we've not prepared our heads in written submission, he's of the view that he's not comfortable to proceed because that implies that we're not fully prepared to represent him. And so his instructions are that if the commission is not willing to at least grant us this afternoon to ensure that we have those documents before you and that we have our heads put together properly, In the alternative, he has no option but to instruct us to bring an application interdicting the proceedings of this hearing, pending the review of the decision for us not to get a stand down until tomorrow.
You said something about this afternoon, and now at the tail end you say something about tomorrow. Can you please clarify?
Chair, you'd recall when we began our discussion earlier on, we were requesting that the commission stand us down until tomorrow morning, at which point we had made an undertaking that we would have served you with our replying affidavit and our heads of argument. And so what the instructions are is that our application on an urgent basis would interdict the proceedings of the hearing or him giving testimony pending the reviewing of the ruling that you would have made, which is that we must proceed with arguing this matter, because he's of the view that it's unfair that he's been placed in this position where he has to proceed without Van der Heerver, who is his lead counsel, and without heads of arguments before you, which he believes then implies that we are not properly prepared and we're being strong-armed into proceeding.
Now, this time around, you've not said anything about the afternoon. It's what you said about the afternoon that I want to understand.
Yes, Chair, what I meant is that if we stand out now, it'll imply that we only have this afternoon and evening, I suppose, to ensure that we get the documents before the commission. So that's what the afternoon referred to, that if you do change your ruling into us standing down or postponing until tomorrow, it means that it's just this afternoon that would have to ensure that we have bring the documents or serve them on the commission and the evidence leaders. That's what the afternoon was.
Oh, you keep repeating that because you don't have your written submissions, you are not ready. Written submissions, yes, they do assist legal representatives, but in the main, written submissions are prepared for the assistance of the decision maker and not so much the arguer. Do you want to address us on that distinction? So those would more have been of use to us, but seeing that the written submissions are not there, we are prepared to forego the assistance we would have received from your written submissions. So as I say, it's more for us than for you.
Chairperson, having engaged with client afterwards stood down, and obviously with what he had heard during our discussion, his instructions to us is that his observations and his views is that if Ms. Van der Heerver is not here and we have not prepared our arguments for you, it implies that he's not going to be properly represented and he's not comfortable proceeding, which is why he's intimated that should the ruling not be changed to allow us to stand down till tomorrow, it implies that he's of the view rather that he's being treated unfairly and he would rather approach a court to have that addressed, Chair. And I do note that you're distinguishing the difference between written submissions and who exactly they're meant to assist, but it's client's instructions that he's of the view if his lead counsel is not here, together with us having not produced the heads before this commission, that he's not properly represented. And unfortunately, I can't comment any further than that because, as you do know, myself and my junior, my apologies, Chair, I forgot to put Ms. Brighton onto record. She's the third junior on the matter. And consequently, he's of the view that he's not willing to proceed, and he would like an opportunity to have this addressed before a court, Chair.
May I ask an issue that we did not raise before? It is this. Why is it that there is no substantive application for a postponement with sufficient clarity? Now it has just been emphasized to us that, as I understand it, the main reason is the fact that lead counsel is not here. Why is it that no substantive application for a postponement on affidavit was brought?
Chair, I think for one, we did not anticipate that we would find ourselves in a position where we were not able to firstly consult with Mr. Matlala yesterday to get the additional information that we needed. Before we left, I did intimate that there is a document that is imported, and it speaks to one of the bases upon which we bring this application, but it's obviously of a factual nature. He had to bring it here in the morning, so that's one element. The fact that we didn't anticipate not being able to prepare the replying affidavit. Number two, that then created circumstances that follow when we were not able to proceed and prepare the heads of argument on time to be to serve on the evidence leaders and for the commission to have signed off. And so those are the reasons why we were not able to prepare ourselves on time or rather, finally, we hadn't anticipated that Ms. Annaline would fall so ill to a point where she's unable to even be here in person. Because perhaps her being here in person as the lead counsel, we would have had a better argument, so as to say, and it maybe have created way for us to proceed to argue on a legal basis. But one thing I can say is that our instructions from client is that if his lead counsel is not here, he's not comfortable and he doesn't feel properly represented.
But the main reason throughout for not proceeding today is the fact that you did not have all the documents you think you require, and that was known for quite a while back, and that had nothing to do with Ms. van den Heever's being here or not being here. So at some point, especially because this morning a postponement is sought on the basis that these documents are not available. Your argument, that was the gravamen of your argument this morning. A reference to Ms. van den Heever not being well was something that was said in passing in your argument. Main reason, the fact that no replying affidavit had been filed, and also the fact that written submissions had not been filed. So the short point I'm making is that that's something that was known for quite a while. At some point, a decision should have been made that, seeing that we don't have these documents, and because we do not have them, we are going to seek a postponement. Let us bring a substantive application for a postponement. That's the point I'm making. The issue about lead counsel not being here arises because I have now directed that we as a commission want to hear argument on the application, on the points in limine. That's when now the issue of Ms. van den Heever's absence takes center stage, and that has nothing to do with why this morning you argued that there should be a postponement. I hope you do get that distinction. Can you address me on that distinction in particular with regard
Chair,
to...
I do
Just
get that.
let me finish. With regard to why there is no substantive application.
Chair, firstly, I'm just getting notes from a junior. Ms. van den Heever would have been prepared to argue the matter whether there were papers before us or not. That's the first point. Secondly, we don't anticipate an instance where she would be ill and not be in a position to appear before the commission, which is why we were unable to prepare a written postponement. Because in the morning when we engaged with her and she was being rushed to the hospital to go and have her ailment addressed, we hadn't anticipated that she would not be here in person in time for us to then prepare a written postponement application. What I can assure is that the letter that you sent indicating that you haven't received a postponement application and will proceed absent of that application, we received it at around past 7 in the parking lot of the venue where this commission is being heard. And so, Chair, could we have prepared the postponement application? If we were in this position that we found ourselves in the morning the night before, we would have endeavored to prepare the postponement application. That's with certainty. But because this is something that happened to us in the morning, and my instructions were to come before the commission and to ask us to postpone only till tomorrow, that's the reason why you don't have a written postponement application.
Now, I just want to get an idea of how things are to unfold. In the event that I'm not saying we are adopting that stance, but in the event that we adopt the stance that we go ahead with the hearing of Mr. Matlala's application, how will things unfold then? Will you walk out? Will you withdraw as Mr. Matlala's legal representatives? Or I just want to get an idea of how things will unfold. Going further and saying, if we get to a point, and underline if we get to a point where, having heard Mr. Matlala's application, we do not grant it, and we go ahead with the hearing of his evidence in the normal course, with him, of course, being entitled to raise whatever privilege he may want to raise. So I want you to address me with regard to how things unfold, even looking ahead up to and including that furthest or farthest point.
So, Chair, as you rightly pointed out, it's either one of two options, which is the fact that it would be removed off the brief as his counsel and possibly even his attorneys. The alternative being that you would grant us another ruling, which is perhaps to say within a certain period of time, please ensure that you've served and filed this urgent application with your Part A and your Part B to review my ruling, and at which point would get the opportunity to do so. I must say I wouldn't have...
The application, the interdict, I assume that's a High Court interdict, so
Yes.
time frames with regard to that would have nothing to do with us. So
Chair, when I refer to the time frame,
Yes.
I'm referring to in terms of us ensuring that we've served you here and not what the High Court or the senior judge sitting would determine would be the ideal time for the urgent to be heard. That's just, again, ideas that I'm throwing out.
And may I, sorry to interrupt you. And as you are making your submissions, again, bear in mind, I started with two big ifs. If we reach that point, you should be aware that there will be no interdict in existence at that point. Which would mean that nothing stops the commission from going ahead and hearing Mr. Matlala's testimony.
Chair, as I said, that we hadn't foreseen an instance that the commission would possibly consider not granting us an opportunity to approach the High Court and address the application that we seek to be heard on an urgent basis. And if that is the case, I don't want to preempt what we would do if you decide not to grant us that opportunity, because for me, it's a matter of you're either changing your ruling, allowing us to stand down till tomorrow. The alternative, you say, no, I'm not granting it, at which point the question as to whether are you going to rule, to say, okay, since you've intimated that you want to have my ruling heard on an urgent basis and reviewed, then you are welcome to do so, I excuse you. But if you choose to proceed without excusing us and thereby Mr. Matlala, I would then ask for a stand down, because then there are implications on him that would affect us, i.e. for one, walking out, and who gets to walk out, and if, for instance, counsel is removed off the brief, what are his options? And should he decide that he wants to walk out with us because he feels that he's being unfairly treated and is not being given an opportunity to be heard till tomorrow morning, with our undertaking being that whether Ms. van der Heerwe is here or not, we would have to ensure that I, being then the lead counsel, is prepared to continue and present before the commission. Then again, as I stated, we hadn't taken instructions, but then I think it would give us, if you could give us an opportunity to stand on further, depending on what your ruling is, to engage with him and consider what the implications would be, because there are different implications should you decide to protest and want to walk away, and who gets to do the walking away, and what those implications as well would be, Chair. I think it's wrong for me to preempt an instance where we decide, because walking away seems to imply that we are protesting, because we'd be walking away in protest. And if you walk away in protest, we've seen in previous instances what the implications are, and the client would have to consider that, and he'd have to give us instructions, Chair. I can't preempt to answer your question.
Thank you, Ms. Missy. Ms. Hassim?
Chair, I've been listening closely to my learned friend, and it feels like the reasons keep shifting for how we've come about to be in this position. Whether it's because the last submission that Ms. Messi made was that she would make an undertaking to proceed to deliver the argument in the absence of her leader. But if that is the case, then what would be the need then for the postponement? So, and for the urgent interdict? It's not entirely clear to me. It seems to me that, and I have some sympathy for Ms. Messi and Ms. Brighton, the juniors are placed in a difficult position where they have to step into the shoes of their leader. The leader has become unavailable for reasons not in her control. This is what happens in practice. And we are often called upon to step into the shoes of our leader on short notice and to be prepared to do so. It's not an easy position, but it is one you assume when you take on a brief and you're junior counsel. While I have sympathy for their position, it doesn't absolve them of their obligation to take the place of the leader. They were aware that Ms. van der Heever would not be available today. This could have been brought to our attention much sooner. One of the reasons that was advanced by Ms. Messi for the delay was the inability to consult with the client. That is not a ground, an adequate justification for a delay. That was in response to the chair's question about why didn't you bring a postponement application? Because it isn't the inability to consult on the law doesn't avail Ms. Messi on this. This is a legal argument that is to be made. So, and I've been instructed to put something on record. And I do so without having had the opportunity to make it, to alert my learned friend of this, because it's only came to my attention now while I'm sitting here. And it goes to the point of the complaint by Ms. Messi of the inability to consult.
Is it not Missy? Is it?
Miss Missy, apologies.
Yes.
Maybe I've got soccer on my brain. It's only come into my possession. I'm instructed to put it on the record. And it's a message from the area commissioner for DC, Department of Correctional Services, Commissioner Khoza. And what he says, and this is received at 11:36 this morning, and as I said, I'm instructed to put it on record. I'm not going to read the entire thing into the record, just the factual part, not the comments, if I can put it that way. So the relevant part of the message is facts provided are not true. I am not even aware of the challenges advanced to the Commission. I think the challenges that were complained of. And then the next message, they consulted for 3 days and we are prepared to make concessions anytime because we understand the importance of the Commission. I checked with the head of the center, Mr. Kabengu, on all these challenges. He also denied to have created any disadvantage to them. So that's a message from the Area Commissioner Khoza. And as I said, Chair, I'm just putting that on record. None of that actually changes the legal position that is before you. And the legal position is that a stated intention to launch an urgent application does not itself suspend this Commission's proceedings. Unless and until there is an order from a High Court that interdicts the Commission from proceeding, it can continue, subject, of course, to the Chair's discretion to adjourn. And maybe what I should do on that score is just refer the Chair and the Commissioners to two authorities. And the first is the Constitutional Court judgment in City of Tshwane, Metropolitan Municipality versus AfriForum. And it's 2016, volume 6 of the South African Law Reports, page 279. And as I said, Chair, the judgment of the Constitutional Court, and the relevant paragraph is paragraph 74. And then, as it happens, the other judgment I'd like to refer the Commission to is actually the Zuma judgment, but not the one I made reference to this morning, which was Justice Jafta's judgment. It's the other judgment, Justice Khampepe. And the citation of that judgment is Secretary of the Judicial Commission of Inquiry into allegations of state capture, etc., versus Zuma. 2021, volume 5.
Sorry, there was a cough. Volume?
Volume 5.
Thank you.
SA Law Reports, page 327, at paragraphs 94 to 95. So with those, that's also, yes, it's Acting Deputy Chief Justice Khampepe writing for the majority. So with those legal submissions, Chair, we request that.
What do the cases say?
Let me take you to
You don't need,
the City of Tshwane.
you don't need to quote verbatim. You may just tell us the substance.
Well, it supports a proposition, Chair, that proceedings are not halted pending an intention to bring legal proceedings. It's not halted even if you have brought the legal proceedings, and of course we know here there hasn't yet been a filing of an urgent application. It is a stated intention to file an urgent application. So that's the proposition. Well, let me just say, Chair, if I could just quote this one short aspect of the City of Tshwane judgment at paragraph 74. It reads as follows: it needs to be stated categorically that no aspect of our law requires of any entity or person to desist from implementing an apparently lawful decision simply because an application that might even be dismissed has been launched to hopefully stall that implementation. Any decision to that effect lacks a sound jurisprudential basis and is not part of our law. It is a restraining order itself, as opposed to the sheer hope or fear of one being granted, that can, in law, restrain. To suggest otherwise reduces the actual grant of an interdict to a superfluity. That's a paragraph to which I referred the Commission to, Chair. So with those submissions, we request that the application from the bar, as it were, for a postponement should be dismissed, and that we should be in a position now to proceed with the questioning of Mr. Matlala as has been planned for some time.
I think the questioning would, if we do get there, the questioning would come after, depending on whether the legal representatives will indeed not be here, but the questioning would have to follow after Mr. Matlala, if he's all by himself, has been afforded an opportunity to move his application in person. So we won't, assuming that we are with you,
yes,
we won't straight away go to the hearing of Mr. And again, assuming,
Chair,
I was once misunderstood by counsel, and we had an unfortunate heated altercation, he and I.
We don't want to have a repeat of that.
So-
I understand the Chair clearly.
Yes.
Of course, and I don't wish to preempt any deliberation and ruling by the Chair and co-commissioners.
Yes, yes.
My submission is merely putting forward the position of the
Yeah,
evidence.
that actually takes us to a request that was made by Ms. Missy when I asked her how things would unfold if, and Ms. Missy requested a brief stand down for her to take instructions. I would assume you have no objection to that.
I have no objection, Chair.
Yes. Ms. Missy?
Chairperson, I did miss quite a bit of your interaction with Ms. Hashim because I was trying to figure out how we're going to reply to the submission that she's made. Am I going to be given an opportunity to respond to the message that she received? I want to ask that first.
Please do respond. Yes, yes, yes.
Firstly, Chair, the only thing that I will say is that those submissions were with regards to from Friday up until Sunday, the filing of our founding affidavit together with our consultation towards preparing a replying affidavit and the heads of arguments. It does not speak to any interaction prior to that. Secondly, if I'm being challenged on the submissions that I've made to this commission with regards to that on a factual basis, I do believe the timestamps of when I went in and went out, because I was present on Friday and I was also present on Sunday, can be looked at. That will show you how long I waited, where I waited, what happened, and ultimately, for example, at what time I got the opportunity together with my learned friend, Ms. Brighton, to eventually sit down outside of the Correctional Service Center and rather email the signed affidavit. So with that being said, Chair, I can only say that if I'm being questioned as to whether I'm misleading the commission or I'm casting a particular view about the Correctional Service Center, I'm not. I was simply saying that the commission is not aware, and any layperson out there is not aware that they have rules and they keep to their rules, and that has affected how we operated on Friday, Saturday, and Sunday. But if I'm being questioned, the timestamps, and I'm sure they have recordings, the times we signed in, as well as cameras to indicate whether I'm misleading the commission or not. That's as far as I can take it.
Thank you. There is no way that based on what we are told from the bar, from both sides, there's no way, seeing how contradictory the two versions are, that we can take a decision on that. And in fact, I think for present purposes, it's not even necessary for us to take a decision or to go there at all. Do you wish to reply to the rest of...
Chair, sorry, that threw me off a bit. Oftentimes when you are on the legal representative side and you're being called to question about whether you're lying or not, it does throw you off because it speaks to your integrity as a legal representative. I wanted to, because I believe in our earlier engagement, I wanted to distinguish between the position that's been taken by our client, Mr. Matlala, as well as the arguments that are made earlier on, Chair. So the arguments that I made earlier on are in relation to us, whether we can proceed and why we're saying we should stand down till tomorrow. The second element of it, having come back and taken instructions from clients, those are his instructions about how he feels in terms of us having to proceed. Should you insist that we proceed today and not wait till tomorrow? So there needs to be a distinction between the two. We're not shifting the goalposts from this is what we were saying earlier on in the morning, and now we're changing and we're saying this here. What I spoke to mainly, now that we've come back after the stand down, is with regards to the instructions and his observation, how he feels about it. The earlier part still stands as it is, where you are asking us and we have to address you as to whether we proceed or we don't proceed, and you made the ruling that you made, which is that we proceed at 12:30. So I just needed us to make the distinction.
You do still need this stand down with regard to how things will unfold in the event that the decision is we are going ahead.
Chair, we
And
still do
my
need to
questions-
stand down, but
All right,
we had a discussion when we were hoping that it doesn't come off as if we're being hostile as,
Not at
because if
all,
someone
not at
has
all.
underlying
No,
for
no.
us that, oh, so now you need to go and preempt, are you going to walk away from us? It gave that impression, but if,
No, it's just wanting to know how
Yes.
things are going to unfold. There's nothing judgmental about it, and I have not observed any hostility. I just want to know how, if we do get there, again, underline, if we do get there, what's going to happen?
Chair, I would appreciate the stand down.
Kuzakwenzeka ntoni?
Chair, I would appreciate the stand down to just
Yes.
quickly take instruction from client, and then I'll come back with a response if you do decide to
If,
advance.
yes, thank you.
Noted, Chair.
Thank you, Ms. Hasim.
Chair, it's very important for me to make one remark.
Yes.
And it's in relation to the message that was received by the
Yes.
area commissioner.
Yes.
My instructions were simply to put it on record.
No.
I take no position on whether
Yes.
my learned friend, Ms. Missy, is misleading this commission or anything like that.
Yes.
That's not my intention, and I do
right.
not wish to be misunderstood at all, to be suggesting that. It's simply an objective
Yes.
message that was sent through that I put on record. And I think perhaps what it is from the commissioner's side to say, we are not being obstructive.
Yes.
But the fact that it is difficult to consult with a client who is incarcerated, if any of us who have gone through that understand that it's a difficult
Yes.
process. And so I just wanted to make that clear.
An important takeaway actually from that text is this, as Ms. Missy was arguing this morning, I actually did think of the possibility of the commission engaging with the prison authorities to ensure that the difficulties Ms. is telling us about do not recur. Now, a good take-home or take-away from this text is that such an engagement will actually, there will be no resistance to the request that I already had in mind.
Quite so. Thank you, Chair.
I will not indicate it. Yes.
Chair, my little friend just highlighted something. I did speak about how we often use our cell phones for internet. We use our cell phones to get Wi-Fi through them to connect to our phones. If that request could specifically include that we have our cell phones, because that would really make things easier for us should we have to engage with him later on, to allow council at least one cell phone to come in with us. We don't all have to have our cell phones with just one cell phone so that we don't have this issue of internet not being present, etc. Because what would happen is that, for instance, if we need to have a document and he's happy with it and we have to file it, it's just a matter of him signing it, we can scan using our phones. So, and then we would be able to send it immediately and wouldn't have all these issues of, we don't have the internet, we need to leave, we need to come back, etc. So a request that you specifically include there that we are allowed to carry in one cell phone for purposes of having access to the internet.
That will be considered.
Thank you, Chair.
I'm saying considered. Let's adjourn. I will not indicate a time.
Anticipate that you would say yes. I'm giving you the additional hours and I want those documents, and whether you're prepared or not, tomorrow proceeding, that's when we win and we get our kitty and we walk away. In the instance you rule that no, we are proceeding, our options would be to go off record as his counsel, and he would be without representation, it implies. Given the fact that...
Counsel only or counsel and attorneys?
Counsel and attorneys.
So, or you will no longer be representing him?
That's correct.
Yes.
So that would be the hypothetical scenario that we'd find ourselves in if you decide that you're not willing to give us the additional time to come through prepared tomorrow. Again, I do want to stress the undertaking that we're making, which is that should you decide to rule to give us the additional time, whether Ms. van der Heever is here or not, we will be proceeding to argue. Whether you have received the papers or not from us, we will proceed to argue orally with or without the papers.
You say when?
Tomorrow morning,
Tomorrow,
should you decide to rule in our favor that we should go home and come back tomorrow prepared, what I'm intimating or suggesting is that the scenario you would have is that whether we file the documents or not, we will be proceeding to argue. Thanks.
Thank you, thank you.
Ms. Missy, when you say off the record, you mean you withdraw as his legal team?
That's correct, Chair.
Would that go for Ms. van der Heever as well?
Those are the instructions that I received as well with regards to,
you would
so it would
also
be the
withdraw.
entire team.
Okay.
Thank you, Commissioner.
Oh, and there was, yeah. When she placed you on record, Ms. van der Heever, last time, she said there was another firm of attorneys as well. Are they present here, and do they also withdraw? Because it's not just the people that are sitting behind you, as we understood here.
Yes, I actually just realized right now that Mr. Maluleke is and his firm still is part of this team, so they would also withdraw from there. Can it be the entire team, all attorneys and counsel?
That's your instruction from Mr. Matlala?
Those are our instructions.
From Mr. Matlala?
That's correct, hypothetically speaking. Yes.
Mr. Maluleke is not with you. Has there been a discussion with him? Because it's important that we don't end up with a situation where if this eventuality that you're contemplating happens, that we don't end up with a situation where he comes to the commission and said, I never put myself off record. The team that was here on Monday were not speaking for me, and I hadn't spoken to Mr. Matlala. So I think it's very important that we are clear about that.
I'm glad that you raised it because that could potentially happen, hypothetically speaking. And with that being said, because these are instructions and engagements that we had with Mr. Matlala and Mr. Maluleke is not here in person, I suppose then, in fairness to him, he has not commented on that element. These are just instructions that the entire team would be off record. But I suppose in that instance would have to engage with him and consider his stance should we find ourselves in that position. I suppose there won't be a need for us to stand on further until we've had a ruling. It just gives an idea of where we potentially would be. And if that is the case, we'll engage him and inform the commission of his position.
Yes, I think, Ms. Missy, this eventuality that you're contemplating, I think it's very important that we all are clear what it is you're saying. You are using language of the record. My experience is counsel say, I'm withdrawing. I'm no longer on brief. I'm not counsel on brief in this matter, and I'm withdrawing because for their personal reasons or because that's the instruction from the client. So just so that there's no confusion, can we clearly understand you? You are saying in the event you do not get, I'm going to say your way, because that's what it is. If you don't get your way or Mr. Matlala's way, you are saying to us your instruction from Mr. Matlala is that the entire legal team, and I'm happy to leave aside Mr. Maluleke for now, you're saying your instruction is that the entire legal team, counsel and attorneys, including Mrs. van der Heever, you withdraw as counsel.
That's correct, Commissioner.
Okay,
That's
thank you.
correct.
who is the senior attorney? This is something that that's so crucial that I think we should hear from the attorneys directly. Who is the senior of the attorneys? And can
That would be Mr.
please,
Baloyi.
please come to the microphone and. No. Please state your name for the record
Thank you, Commissioner.
and your firm.
Yes, it's Mr. Baloyi with initial N from Baloyi Attorneys in Pretoria. Yes.
I asked if you also confirm that if our decision is that we proceed with Mr. Matlala's application, is your decision that you, as Mr. Matlala's attorneys of record, are withdrawing from representing him? If our decision is that we are proceeding, is that, do you confirm what counsel said?
Yes, I do confirm the submission made by the council.
You will be withdrawing, yeah. Perhaps, thank you very much, Mr. Baloyi. I think we've reached the stage where we should. Ms. Asim, I'm not sure that you would want to say something, but perhaps because this is not really your decision, if haven't we reached a stage where we should just indicate what we think?
Chair, there was
Or what I think, because I think our regulations and rules really say that process-related decisions are mine, and indeed all rulings that have gone out go out. Even if signed by the Commission Secretary, they go out under my name. But of course, for practical reasons, I'm always assisted by my co-commissioners. But ultimately, it's my decision.
Chair, there's
Yes.
nothing that I can usefully say in response to the last
Yes,
submissions that have
yes.
been made about withdrawing, etc. So it's in the chair's hands.
Yes, thank you. I will address Mr. Matlala directly on this. Mr. Matlala, I just want to get an idea whether you two confirm that after your counsel or legal representatives were afforded an opportunity to consult with you, what was agreed upon is that if my direction is that we go ahead with your application, they will then withdraw as your legal representatives.
Thank you, Chair.
Can you please switch on both microphones? Yes, thank you.
Thank you, Chair. Chair, we had three scenarios, so I'm actually in the dark now because while I was having lunch, I didn't have enough time to conclude what we've been discussing. So we just came right straight here. So I do not know whether my legal counsel, what they are saying now is what comes from Mrs. van der Heever as instruction or not. So I'm actually in the dark. I don't know what to say.
So basically, you are not really party to what has been announced.
No, we've discussed the options, yes, but I haven't had the time to make up my own mind. So
All right. Maybe the best is for me to announce the decision. Having considered everything that has been presented to the commission, my decision is to go ahead to hear Mr. Matlala's application. That's the decision. Ms. Missy?
Chairperson, given the fact that Mr. Matlala, being our client, has now confirmed that he hadn't settled his mind because we labored under the impression that this is where we're standing and these are our instructions, given the fact that he's of the view that he feels confused now, he's no longer witness, will you please grant us an opportunity to then finalize and get the instructions so we don't have this situation again?
Ms. Missy, the withdrawal of counsel and legal representations is not, strictly speaking, a matter of instruction from client. It's ultimately a decision taken by the legal representatives. They choose on their own for whatever reasons that we have now reached a point where we can no longer represent our client. Therefore, we are withdrawing as legal representatives. I don't know whether you are now suggesting that it was not a properly considered decision. I'm not pushing you to
Yes, Chair.
to withdraw if you've suddenly become ambivalent about it.
Chair, remember we were operating under hypothetical instances. Now that we know definitively what your position is, I do believe that we ought to be given an opportunity to finalize if really we're sticking to that position of walking away or not. As you've noted, that perhaps we might feel a bit ambivalent and would feel we want to continue. This was what we're simply requesting, Chair.
Ms. Missy, what's happening now is deeply problematic. I asked you directly, is it your instructions from Mr. Matlala? You said yes. That's deeply problematic. Whatever stand down you get to go and consult with him, I would like you to end on that note from me. It's deeply problematic what's just happened now, and I hope you find a way to address it. Because what it suggests and represents is what you said in response to my direct questions, is that is not the true position, given what Mr. Matlala is saying now. If you come back to say it was a misunderstanding in whatever form, that I'm prepared to grant you that, but it is deeply problematic that you have put family, those are your instructions from your client. And now you say, well, maybe we need to go and discuss. I want you to understand my concern about it.
If I may, Commissioner, I do understand your concern about it, and that's the reason why I specifically have asked if the chairperson, the commissioners, could let us stand down, because I was laboring under the fact that those are our instructions. Now that he has intimated that he does not feel that he's on the same page with us and he does not understand, that implies that there's been a misunderstanding, and that's the reason why I would like for us to address this, so that when we come back before the commission, then we don't have this issue happening again. And to add over that, if you recall, this is a hypothetical situation that we're talking about. Now that you've made your ruling, that implies that we need to come back to the chairperson with a final decision of what are we going to do. Chairperson, I don't know if...
And as I said in my ruling, at this point, this is only about hearing Mr. Matlala's application. We have not reached the stage of the continuation of his testimony. That's where we are, just for clarity.
Thank you, Chair and Commissioners.
And Mr. Matlala, you are fortunate to have had lunch already. we are yet to have ours. No, I'm mentioning that because you said when you were having lunch earlier during the break that we had. Because it's 3 minutes before the lunch adjournment, maybe let's just take the lunch adjournment and resume it at 2 p.m. And let's have, let's
Thank
hear
you.
from you, Ms. Missy, at that point.
Thank you, Chair.
And I hope everything will have been clarified and that one way or the other will then hear Mr. Matlala's application, whether you continue to represent him or whether he is moving it in person. Let's adjourn and resume at 2 p.m.